Well, hello again. Welcome. Employment Law Show. John Scholes, Lior Samfiru beside me, taking all of the heavy lift and the phone calls, which we're going to get from our radio show, which has been on for many years. By the way, I'll tell you right away, employmentlawyer.ca, the website to find a station near you. We can catch that. Anytime you want to call Lior, member of the team outside the half hour of the radio show or the TV show here, no problem. 1-855-821-5900 and help at employmentlawyer.ca. Lior, we're going to get into leave of absence, what employees need to know about that a little later in the show. But lots to get through before that. So week that was, what do you got, pal?
Hey, John, I am always glad to be here. Really a pleasure. I think this show means a lot to me because I get to inform people and help people. That's really what this half hour is really all about. If you want to know about your workplace rights, about your work issues, find out solutions to the problems you may be facing with your job, with your boss, with your severance, this is the time, this is the place. We talk about that every week, and we try to provide all the information that you may not be able to find elsewhere. It's the rights you don't even necessarily know you have. It's really the rights that your employer is not going to tell you about, but we're going to tell you about it. So if you want to know and learn and get educated and be armed with the knowledge about your workplace rights, now is exactly the time to do that. But of course, you know, we only are here for 30 minutes. If we can't, and if we do not cover everything that you want to know about or your workplace issues, not a problem, no issue. We'll give you my contact information so that you can call me and we can have a discussion about those issues specific to you. But as always, I want to talk about a situation that came across my desk. And John, I'll put this in the category of near miss or close call, whatever you want to call it. So I spoke with a gentleman who unfortunately lost his job. Many of the victims of COVID-19 lost his job because of it. Now, he had been with his employer for 6 years, and he was offered a severance package of 15 weeks' pay. Now, he was going to have to return it on a Monday, and he had actually signed it and, in fact, emailed his employer saying, I'm going to be delivering it to you on Monday. Well, on the weekend, wouldn't you know it, he saw exactly the show you're watching right now. And he kind of paid attention and he said, wait a second, this guy, handsome guy, by the way, on TV, says severance offers are often inadequate. Does that mean that mine is inadequate? So instead of Monday going to the office to hand over his severance package, he called me and we went over his severance package together. And John, he was owed about 8 months' pay. Wow. 8 months' pay. Now, again, he was offered 15 weeks' pay. That's, I don't know, 3.5 months' pay. So he was offered less than half of what he was actually owed. And for him, that meant about $37,000, $38,000 difference. A lot of money, okay? And because of that, he obviously didn't end up signing. I'm going to help him get that severance package. But think about that near miss. If he hadn't watched the TV, if he had turned his TV on 30 minutes later, he wouldn't have gotten this information. And I'm telling you this not because this is an unusual situation. What I've just described here is a very common one. First of all, people are often offered, most of the time they're offered inadequate severance, usually to the tune of tens of thousands of dollars. So that's issue number one. But the bigger issue is the fact that most people, just like this gentleman, don't necessarily know that they're owed more. He thought that 15-week severance after 6 years of employment was adequate. He thought, well, it's more than 2 weeks per year, so that sounds good. There's just the right sound to it. Not even close. He was owed 8 months' pay. So please, don't be in that situation. Do not sign that offer. 24 hours later, you would have signed off on that severance offer, lost almost $40,000. Please don't let that happen to you. And I'll make it even easier than just contacting me. You can go to severancepaycalculator.com or pocketemploymentlawyer.ca to find out what you're owed. Grab your smartphone, go to pocketemploymentlawyer.ca. There you go. All the information is right there. You can calculate how much you're owed. So many people's job has been impacted recently. Severance packages are a common thing these days, so please do the right thing.
Now, this guy obviously saw the show, so he kind of saved his own bacon. He didn't sign it and got you involved. But this guy felt like he was pretty much in a hurry. He got it Friday or Thursday, felt he had to have it back by Monday. Or maybe they told him to. I would assume there was some sort of deadline on that thing, but he didn't have to pay attention to that either, did he?
Well, yeah, he was let go on a Monday, and he was told the following Monday you have to sign it and return it back to us. There was a deadline on that piece of paper, and he was going to do that. He thought, well, I have to because they told me there's a deadline. But you know it. Hopefully our regular viewers know that that deadline is meaningless. Your legal rights don't expire on Friday or Monday or Tuesday. You have 2 years to pursue your legal rights. It's a pressure tactic. That's all it is. And can you imagine? They owe him another $40,000, but they say, we're going to pay you less, but you have to accept this by Monday. That's silly. It's absurd. So that deadline you can absolutely disregard.
And if he had handed back, there's no going back, right? He can't take it back. Sorry, I didn't mean to.
If he hands it back to the company, goes home, realizes, wait a second, they owe me more,
right,
and calls them and say, I take it back, too late. There is no taking it back. Once you've signed it and returned it to the company, it's done. So please don't let that happen to you. Every day, well, hopefully not every day, but certainly every week I speak to someone who is in that situation, who signed off on that severance package because they didn't know any better. Well, if you're watching us, you know better, so it's not going to happen to you.
So reach out, 1-855-821-5900. We put the number on the screen all the time. Employmentlawyer.ca is the website, which is where we're going to go right now, Lior. That is where you can find our radio show. That's been running for a better part of 9 years now. We take the phone calls from it, play them back here. We talk about them. Phone call number 1 for today's show is coming up right now.
My wife was temporarily laid off on March 26th, and we were waiting for the ROE, Record of Employment. We were told it would come, it would come. We never received it, but now HR has called my wife. She's worked at this place for 5 years, and asked her what she wants to do if she wants to resign. I don't know if she'd be entitled to severance.
Ask her to resign. Ask her to resign.
And this whole situation is so almost confusing.
Yeah.
The company puts the employee on a layoff because of COVID-19, fine. And then the company calls the employee saying, do you want to resign? Why would the person want to resign? The whole scenario is just absurd to me.
Yeah.
So let's break this down a bit. When this person was put on a temporary layoff, they said that was back in March, that temporary layoff was a termination. So at that moment, if she wanted to, she could have chosen to treat that layoff as a termination. Same thing with you at home. If you've been put on a temporary layoff, you have the right, if you want, to treat that as a termination now. You don't have to wait to see what the company does. So number one, this person could have gotten their severance then. That hasn't changed now. Her employer saying, well, we may not bring you back, so do you want to resign? That's silly. That's absurd. That's a termination. So it's like saying, well, I'm going to hit you and tell me if you want to be hit. You've already been hit. It's done. It's over. Well, in this case, she's already been terminated, so she is absolutely owed severance. So the question then becomes, well, how much severance? We know she's been terminated. We know she's owed severance. So how much? PocketEmploymentLawyer.ca, the place you can go to find out. So let's take this information, let's plug it into PocketEmploymentLawyer.ca so we can see how much she's owed. So let's say she's in a professional job, working there for 5 years. I picked an age, let's say she's 63 years old. We can see on PocketEmploymentLawyer.ca that she's owed anywhere from 8 to 10 months pay, 8 to 10 months of compensation. Now, depending on her income, that could be anywhere from $50 to $60 or $1,000 or even more than that. Now, this is an employee who was told that she could resign. She's been terminated. A temporary layoff, even if it's because of COVID-19, is a termination, or at least gives you the right to treat that as a termination. For her, severance up to 10 months pay.
Another place for you to go, terminationquestions.com. Yes, I'm going to throw another website at you, terminationquestions.com. You can lay them in there, and Lior, member of the team, will get back to you with a full answer. Want to get to one of those today on the show, Lior. First one for the show comes from Kay. Says, I just lost my job of 4 years with a software company. I signed the same 12-month contract with them every year. I know that I'm not owed severance because I'm a contractor and not an employee, but my husband doesn't agree. Husband is very smart.
Well, it is rare, I'll say this, that the husband is right. Usually it's the wife that's right, at least in my house. But this is exactly. But this is one of those rare cases that the husband is absolutely right. And all jokes aside, most people, many people, are misclassified as independent contractor. Now, if she's been working there regular hours, full-time for 4 years, she's an employee. It doesn't matter what she signed. It doesn't matter that piece of paper that she signed. So she's an independent contractor, no, by name only. She's not really. She's an employee. So how do we know if someone is truly an employee? Well, ask yourself, do I have a regular job? Do I go to work, do my job, come home, do the same thing the next day? Do I have a boss? Am I part of the company, the organization? If the answer to any of those questions is yes, you are an employee. So if this person is let go after 4 years, she's owed severance. That could easily be 6 months' pay. Now, she may not think she's owed because she thinks she's an independent contractor. The company that she works for may not realize that they owe her that because they think she's an independent contractor. But the only one that gets to decide if she's an employee or a contractor is the law. The law makes that determination. Doesn't matter what she thinks, doesn't matter what the company thinks. So because of that, that's what the answer is. 6 months severance. Doesn't matter what she signed. Doesn't matter what you sign if you're in that situation. If you're an employee, you're owed severance as an employee.
So she signed like 4 contracts, was there, one a year for 4 years. What's the threshold where it becomes, where it doesn't matter if you signed a contract, 5, 6, 10?
We see that often with employees, that you sign a number of fixed-term contracts. I see that often, let's say, with teachers, private school teachers, that every school year you sign a new contract for the school year to come. Here's the reality. If you sign 3 or more of these contracts, they become meaningless. You're now considered to be a regular, indefinite employee. And the reason why that's important is that at some point, if the company now says, well, this time, we're not going to renew the contract. This time the contract ends, you're out of here. Well, they still have to pay you severance because that contract is meaningless. You're now no longer on a fixed-term contract. So 3 usually is that magic number, John.
And how far, if you've realized that you've been let go, so now you're owed severance, how far does that go back? If I've signed a contract every year for 12 years, okay, we've determined I'm actually an employee. Does my severance go back 12 years or just 3 years in?
Absolutely. 12 years, 20 years goes back to your start date. So if you signed the same contract for 12 years, now you're let go, you're owed severance as a 12-year employee, which could mean a year's pay. It could be as much as 18 months' pay, depending on your position. So yeah, it goes back to your actual start date.
All right, coming up here, leave of absence, what that means for employees. Stick around for that. In the meantime, I'll give you a number, 1-855-821-5900. help@employmentlawyer.ca is the email. It's the Employment Law Show. Don't go anywhere.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Employment Law Show. Lior Samfiru, John Scholes. Leave of absence. I'm sure you're familiar with that term. Maybe possibly you've been on one, but let's break it down over the next few minutes, Lior. Leave of absence, if you're an employee, what you need to know. What is, break it down, a leave of absence?
Well, a leave of absence is a generic term that refers to time away from work, time that's an approved time from work where you're still an employee of the company. You haven't quit, you haven't been let go. You're just away from work. Your employment essentially gets suspended for a period of time until you come back. There's a number of types of leaves of absences, so we want to talk a bit about when that can happen and what the rules are when it comes to those leaves of absences. We've seen them a lot, certainly now with COVID-19. Sometimes people have taken leaves of absence maybe because they didn't want to go back to work, they didn't feel safe. Maybe in other situations they were taking leave of absence to take care of a family member. So we want to really address those so that people know what their rights are, and even for employers to know what rights and obligations are.
If you're an employee looking for a leave of absence, you go and you ask your employer, can they refuse to give you the leave?
So there are some leaves of absences where it's not up to the employer. Okay? So for example, if you have a medical condition and your doctor says you need to be off work, that's a medical leave of absence. You can take that. You don't need permission as long as you have the doctor's note. There's other types of leaves of absences depending on where you are. There's leaves of absences that allow you to care for family members. There are leaves of absences to provide care for someone that's sick. So there's those leaves of absences that are mandated by law and an employer doesn't have a say in it. Now, but there's other leaves of absences where maybe it's something that you do need to talk to your employer. For example, if it is a situation where, you know what, I'm not comfortable right now going to work because of COVID-19. Thankfully, I'm not sick. Thankfully, my family's not sick. I just don't want to be at work. I want to be at home. I want to take some time off while we're dealing with COVID-19. That is a situation where the employer does not have to, by law, provide you a leave of absence. So that is one where you can and have to, in fact, ask for that permission. And of course, if the employer says yes, no problem, then you can be on that leave of absence, but not without the employer's consent and approval.
How about keeping up the old paycheck? Does the employer have to continue paying you while you're on a leave?
So generally, no. The answer is that an employer does not have to pay you while you're on a leave of absence. Now, some employers have policies with respect to sick days, so you may be able to use those sick days. You may also have compensation through other means. For example, if it's a medical issue, you may have short-term or long-term disability benefits through your employer, so that allows you to get paid, but the employer generally does not have to pay you while you're off. Now, in some situations, the employer may say, well, as long as you're only gone for this amount of time, we'll still pay you. But the general rule, very important for people to understand, is your leave of absence, whether it's a medical leave of absence, caring for a family member, whether it's just one where you need a mental break from work, an employer does not have the obligation to pay. But as I said, there may be other resources that are available to you.
Does a leave of absence impact the employer's length of time with the employer?
That's a very good question. So your seniority continues while you're on a leave of absence, regardless of the type of leave of absence. Maybe it's a medical leave of absence. Maybe it's an absence to take care of a family member. Maybe it's just an absence where you and the company decided that you'll take some time off for yourself. Either way, if you're on that legal leave of absence, your seniority counts and your seniority continues. And the reason why that's so important is that down the road, if you are let go, you're going to get severance, and the severance is calculated based on your length of employment. Length of employment doesn't get interrupted just because you're on a leave of absence. So to use an example, let's say you've now been working for a company for 10 years, you take a leave of absence, you come back, and then a year later, they let you go. Well, they can't say, no, you're a one-year employee because you had that leave of absence interrupting, so we're only going to pay you severance as a one-year employee. No, you're an 11-year employee in that example, so that can have a huge, huge impact on severance. So very important to remember that seniority doesn't reset just because you're off work.
I remember anecdotally, you mentioned that story one time where you had somebody off and they went off on a medical leave and it just kind of, they disappeared into the vapor, and 18 years later they said, hey, employee, I'm ready to come back. And they're like, who are you?
Yeah, that is a true story. A banquet hall, they had an employee work for about a year. Then she had to go on a leave of absence, medical leave of absence, and they forgot about her. 18 years later, management has changed, ownership has changed. She contacts them and saying, hey, I'm ready to come back to work. They have no idea who she is, but they look in their records, they realize, yeah, sure enough, she's our employee. Now that's a problem. Now she's a 19-year employee. If they let her go, they have to pay her severance as a 19-year employee. So there's a lesson there, certainly for employers. Don't forget about your employees that are on a leave of absence.
If an employer's or an employee's off on a leave, can they be fired or laid off or temporarily laid off during that leave?
It depends on the leave. So here's what I mean by that. If you're on a medical leave of absence, you cannot be let go because you're on a medical leave of absence. If you're on an otherwise approved leave to care for a family member, you cannot be let go. That's what's called a job protected leave. So there are many leaves of absences where it would be completely illegal to let you go. If you're on a different leave, one of those leaves that the company did not have to give you, but they agreed to do it, they could ultimately change their mind and let you go with severance. You cannot be punished for being on a leave. The company wouldn't be able to say, wait a second, you went on a leave, so we're going to let you go for cause, because the company would have approved it. But with severance, the company can let you go in that situation. You cannot be let go because you're sick. You cannot be let go because you're caring for a family member. But you are able to be let go, or the company is able to let you go for other leaves of absences where it doesn't fall in the category of a job-protected leave.
When that employee comes back from a leave of absence, can the employer during that time or when they come back make changes to their job? Because it could be quite a long time. Maybe not 18 years, but it could be a year or two. Things change, right?
I've been seeing that now often with COVID-19. An employee comes back to work after being on a leave of absence or on a layoff. Company wants to change the hours, change the pay. The employer cannot do that. Remember, if you're on a leave of absence, if you're away from work, the company and you come back, your job cannot be changed. If your company does change your job, compensation, hours, location, even responsibilities, you may have the right to treat that as a constructive dismissal. Constructive dismissal is a situation where where your job changes, but you choose not to accept that. Instead, you treat that change as a termination of your employment and get severance. So whether you're working already or you're on a leave of absence, your employer cannot make significant changes to terms of employment.
If it's a medical leave of absence and the employee is now ready to come back, but they need some accommodation to the job, does the employer have to do it? Can they refuse?
An employer has a very strict legal duty to provide accommodation, duty to accommodate. So that means if you are sick or if there's a medical condition that requires some help from your employer, in order for you to do your job, the employer has to provide that help. That may mean modified duties, modified hours. That may mean the ability to work from home if that's what's medically required. Ultimately, as long as it's something that's stipulated by the doctor, if the employer is able to do it, they have to do it. Even if it's difficult, even if it does cost the employer money, they have to do it. And if they refuse, that's a human rights violation. There could be significant damages that the employer has to pay. You may even get some reinstatement to your job if the company lets you go instead of accommodating you. So our human rights laws dictate you have to be accommodated if it's a legitimate medical issue.
I want to remind you once again, anytime, go to pocketemploymentlawyer.ca. There's a wealth of information, absolutely free and anonymous for you to absorb anytime you want to go there, pocketemploymentlawyer.ca. But if you're interested in catching our radio show, employmentlawyer.ca is a way to do that. Phone call number 2, Lior, from our radio show is coming up now.
Been off since March. I'm in dental. We're going back tomorrow. But I've been asked to sign a letter stating that they're going to reassess if the company doesn't get back to its 70% pre-pandemic production, then we may be asked to take a pay cut or reduced hours. So I'm not sure if I need to sign a letter like this. He said it's not a legal document. It's just signing below, you hereby acknowledge and agree to the terms of this agreement.
Yeah. So as we're listening to this question, John Scholes here is shaking his head in horror. No. And John is absolutely right. She cannot and should not sign this document. Absolutely not. What this document seeks to do or tries to do is to give the employer the right to do something that it otherwise cannot do, to change your compensation or change your hours. Remember, I said this a few minutes ago. Your employer does not have a right to do that. They cannot change your hours, reduce your pay, etc. But they get that right if you give it to them. And one way to give that right is by signing a document that says, hey, I'm okay if you change my pay. Then it becomes legal. Then you can't do anything about it or even change your mind. So that's a very important thing to understand. If your employer asks you to sign a document, especially now during COVID-19, maybe you're on a layoff or maybe you're not, but your employer all of a sudden wants you to sign a document, I assure you there's a reason for that. And I can also assure you the reason is not one that's favorable to you, the employee. It's a reason that's good for the employer. They want to get rights that they don't otherwise have. They want to limit perhaps their exposure if they let you go at some point. So be very, very, very careful with any document that your employer wants you to sign. If you're not sure what it does or if you should sign it, send me a copy. You can email it to me or even fax it if that's what you want to do. I'll review it and I'll tell you exactly what it means and whether you should be concerned about it. Do not sign anything without doing that first.
All right, lots more to go here. Another phone call. We'll get to some emails as well. First, we've got to take a quick break. In the meantime, the number 1-855-821-5900. The email is help@employmentlawyer.ca. It's the Employment Law Show. We're coming right back.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savannah and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Employment Law Show. A few minutes to go here. Employmentlawyer.ca. That is the website. Go there anytime. You can catch a station where you can catch our long-running radio show. Thousands of hours on air and hundreds of phone calls, Lior. We'll get to our third one for today. Let's hear it.
I was laid off from my company after almost 17 years of work. They laid me off in July of this year. They gave me 8 weeks working severance and then 17 weeks severance. When they gave me the letter saying that I would get an amount, it didn't say anything about taxes or anything being taken out. And then when they deposited it, it was a lot less than what the letter stated. And I wasn't sure what I was allowed to have or up to and including what I should have received.
Wow. This is one that is not gonna end well. Let's put it this way, because she accepted what the company had offered her. So let's start with the easy thing, the taxes. You know what they say, John? Death and taxes, right? Can't avoid those. So there's taxes on anything that's considered income. So yeah, your severance is still going to be taxed, because it's considered income. Not much we could do about that. By the way, there's ways to minimize the tax, including contributing to an RSP and a few other things as well. But generally speaking, yes, severance is taxed. So the real issue here with this call that we got on our radio show is not about the taxes, it's about the actual amount of severance. Now, we know that this person, after 17 years, was given a total of 25 weeks. Now, she was given a few weeks working severance. We sometimes call that working notice. That counts towards her severance. So she got a total of 25 weeks. That's just shy of 6 months. Now, I'm kind of dreading doing what I'm about to do, but let's do it anyway. Let's take our information, let's plug it into pocketemploymentlawyer.ca so that we can see how much she's really owed. And by the way, it's not 25 weeks. So we put that information in. We see after 17 years, her role, her job, her compensation, she's owed anywhere from 18 to 24 months pay. 18 to 24 months. Now remember, she received 25 weeks. That's less than 6 months. So she was owed 3.5 times what she was paid. And if she had signed this, then unfortunately she cannot do anything about it now, even though she was owed 3-4 times what the company had offered her. Please don't let that happen to you. That's why we're here. We're not here because we don't have anything better to do. We're here because we want to help and ensure that you know what your rights are. And those rights are never more important than they are when it comes to your severance. That severance is the money that you need to carry you until you find another job. And if it takes her 18 months to find another job, especially now during COVID-19, she only got paid for 25 weeks. What does she do? That severance is that cushion. That severance is that money that you need. Pocketemploymentlawyer.ca. Chances are, if you were let go, you were owed a lot more severance than what the company wanted to pay you.
TerminationQuestions.com. We'll do this one quick before we wrap. Mitch says, in my latest performance review, my boss said I was underperforming as a senior manager, a role I've held for 3 years. If things do not improve over the next month, I will be fired for cause. What should I do?
Remember, it's extremely difficult to be let go for cause. His employer is going to have to show that not only was his performance not good, essentially that he was doing it on purpose. It's that hard to be let go for cause. So the first thing I would say is don't stress out. Yes, can they let you go? Sure, but they would have to pay severance. If you don't agree that your performance is not good, send them an email. Explain your position. Explain why that's not fair and why you're doing the best that you can. But ultimately, remember the rule for this person and for anyone else watching. It's extremely difficult to be let go for cause because of bad performance. Companies try to do that all the time, but that's illegal, meaning you're still owed your full severance. So please remember that.
Always remember that stuff. Many more rules as well. If you've forgotten anything here in the show, there's an easy way to catch up on it. Pocketemploymentlawyer.ca. It's like having a lawyer with you at all times on your tablet, on your cell phone. Pocketemploymentlawyer.ca. Absolutely free. It's anonymous, but there is a contact button at the top right. You can use that. Help@employmentlawyer.ca to reach out through email. And if we've piqued your interest with the radio show, you simply go to employmentlawyer.ca and do a little searching on the website. You'll find a station near you that catches or at least carries our long-running radio show as well. So appreciate you tuning in. We'll catch you next time. Employment Law Show right here.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.